Alrighty, again, this is We the People News, okay? Never look straight forward, always look around you, be able to protect yourself by any means necessary. What does that mean? Armed. Armed with knowledge. Use your Second Amendment, okay? You're armed. Alright, that being said, everything I say or do is my opinion, okay? There we go. And fast forward to my little words, so we can go ahead and proceed forward on this. All right, I'm going to try to quit cutting in and out.
Distinct population, but he says that judges don't rule blindly. The parties to the case often bring expertise. There are amicus briefs that bring expertise, and the agency's view of that as the experts on the Endangered Species Act in this example can be given weight by the judge that is deciding the case. The point is that the judge owes the public independent judgment on whether the agency's interpretation, its position, is persuasive or not. And I mean,
and they're absolutely not doing that. They're misleading the public and causing bypass. They're making roustabout, violating your rights.
Responses that might happen as a result of the end of Chevron.
Allegedly, for all the attorneys out there.
Deference is that Congress, when it writes laws like this, could offer more clarification of what it means by terms such as distinct population. But then also what happens is you could have a trial, you could have a court proceeding where each side brings in its arguments, one side saying that what the law means by distinct is this, one side saying what the law means by distinct is that. And then it's up to the judiciary to make a real decision about the point, the purpose of the law.
Well, I think that's right, and I think that already is happening, actually. What Chevron requires, or required, was the courts not just to pay respect to the agency's interpretations of the law, but also to basically defer to them, as long as they were quote-unquote reasonable, and oftentimes they were very deferential in terms of...
And when she says reasonable, what's reasonable, all right? Our founding fathers made sure to be let known that everything, all laws are passed, is supposed to be easily understood by the average man. These attorneys are not using language for the average man, and therefore, for our founding fathers' intent, it's unconstitutional.
They defined reasonable, so as long as they aren't way out in left field, judges would tend to rubber stamp them. They would also tend to defer to agencies on whether even terms...
Even this lady right here said they have a tendency to just rubber stamp, right? So when you fight your property tax, which is administrative, which is volunteering tax, and it's not a debt, all right, because somehow or another, you volunteered into paying your property tax. Okay, they just never gave you clarification on that you volunteered into this. Somehow or another, you magically gave implied consent. Look at my other videos about this magic power that the kings have with implied. They get to think what they want to think.
Or ambiguous, and this actually came up in this case, in which the Bright Enterprise ruling, and actually there's a second one regarding the same rule, Commerce Department rule regarding fisheries, and both having to pay for government officials to monitor them off the New England coast. And the First Circuit and the D.C. Circuit didn't actually apply Chevron the same way. One actually said that, well, we actually think the law is unambiguous, and another said, well, we actually think it's somewhat ambiguous, but we think the agency has the authority to do what it did nonetheless. And so what you often have is ping pong, not just between different circuit courts and district courts, but also between...
Which, by the way, is the worst courts. Your lower courts... That's all it is, administrative. Your lower courts just always complies with, against you, with the city, county, and all that, with the government. They just sit there for decoration, people, and violate your rights.
Different administrations. And what the chief really emphasizes in his opinion is that Actually, rolling back this Chevron deference will actually provide more certainty, stability to parties, that because judges will be according the best interpretation to the law and not just any reasonable one, so regulators can't go back and rewrite laws and exploit putative ambiguities as they do now. And so you may actually have, and as you also pointed out, Congress will legislate just much more clearly. There have been so many cases over the years. I mean, I like to point to the Volcker Rule and the Dodd-Frank Act, which was banned proprietary trading, and then the Fed had to write 1,000-page rules to try to define what that is. So you'll actually...
Yeah, 1,000-page rules to define what it is, right? Rules. And you're supposed to figure out this 1,000-page rules that you must comply to. And they don't even know what it is. And the judge goes, it's okay. You know, you guys can be absolute vague and ambiguous, absolutely. And I'm just going to be sitting here against the people.
Have Congress actually perhaps doing its job, and then there are a lot of issues that have come up in Congress in recent years where it's kind of punted to the regulatory agencies. For instance, cryptocurrency, AI, stable coins, privacy regulation, that's another big one. But they've essentially deferred it to the agency.
There we go. Private regulations. If you actually own your property, have dominion over your property, there is no regulation in this by the Constitution. They put you in a taxpayer. Therefore, you implied consent that you're a taxpayer.
Then the agencies have then issued regulations. So Congress has never really had an incentive to actually write and debate legislation. Imagine that. That's what used to happen before Chevron over 100 years ago. And more bills and legislation was actually passed.
Hang tight, we'll be right back in a moment.
Hi, it's Billie Eilish. You can now check out my new song, Lunch, and remix the music video.
Welcome back. One wrinkle here is that Chevron deference was long defended by conservative jurists, including Justice Antonin Scalia, though I think late Scalia was changing his mind about that and becoming more skeptical. And part of the evolution may be just the context. When you were sitting there in the 80s and you had your experience for decades was judges thinking themselves as philosopher kings and coming in and overruling what the political branches were doing, maybe deference looked like a solution. But now we have the opposite experience of
That's exactly what they're saying. Your town has become your king and you're subject to that 12-inch grass, and you must pay $100, $500 per day while that 12-inch grass is on there, because somehow or another they got magic powers and they end up becoming kings over your property.
Regulators run wild. And Kim, the key words to me in...
By the way, that's under administrative.
The argument Alicia just made is the stability of the law. Because again, to go back to this point that Justice Kagan is making about the western gray squirrel and whether it's a distinct population because the Washington group lives separately from the rest, or whether it has to be genetically distinct. Honestly, I'm not sure that the answer to that question matters as much as having an answer to that question. And in the absence of Chevron deference, what you would get is a court answering and saying that geographic separation is enough, or that geographic separation is not enough, and you have to take in some kind of genetic component to decide whether this is the same species as the group of squirrels that is living over the mountain. But with Chevron deference, what you end up getting is this ping pong back and forth where one administration says that these squirrels are distinct for the Endangered Species Act, the next administration says they aren't, and you don't have any stability in the law. And I think what we need more than anything in many of these cases is an answer. And then if Congress wants to change that and change the definition of what a distinct population is, it is free to do so. But that should not be...
And by the way, y'all, all these Second Amendment constitutions taking the court's time, right, is actually administrative. The whole thing is all about administrative. And again, shall not be infringed. And what's that administrative doing that don't sign an oath of office? Infringing on your right. You got to do this, you got to do this, and you got to do this. But if you start reading all these case laws, it's always a corporation bringing this up. It's not one of the people. So the standing is incorrect for the people and only to the corporate persons, which is what you are.
In the hands of regulators who are not elected and do not have the power to make the law.
That's absolutely right, and who are constantly changing as well, too. Look, we've had Chevron deference now for 40 years, and some of these disputes have been stretching on for 40 years, and that's in addition to, as Alicia noted, even in the case that ended up coming in front of the court this time, you had two different courts that were looking at Chevron in different ways. We shouldn't like the word ambiguity when it comes to the law. There are plenty of other reasons. I mean, stability of the law is a very good reason in and of itself for getting rid of Chevron. And the Chief Justice, John Roberts, made that case in trying to respond to what will ultimately be complaints from outsiders about an overturning of a precedent or a judicial doctrine. But he was noting that stability in the rule of law is precisely why we have stare decisis in the first place, is to try to keep consistency. So getting rid
And keep the president from being the king.
of this is actually the best way to promote stable and consistent rule of law. But the other thing that got brought up in this case, which is fascinating, and I think it goes back to the point that this was a little bit of an accidental doctrine. It was never meant to become this sweeping thing that it became. But the Chief Justice notes that it was never reconciled as well with the Administrative Procedures Act, which lays out the ways in which agencies are meant to develop regulations, but also incredibly clearly points out the courts are supposed to be the ultimate arbiters of these kind of rules. The APA was passed back in 1946 as a check on the zeal of the executive branch, and it outright says that the courts, not agencies, will decide all questions of the law. So
Sit and think about that. The courts are kings because the courts gave them magic powers before them, which is actually incorrect by our Constitution. I guess I'm going to make part 3. This will be the People News. Bye, y'all. If you don't think we live under kingship, listen to all these things.